The last two grounds of divorce under section 13.1 of the fault theory or renunciation of the world and presumption of death. So the eighth one, that is renunciation of the world, is by entering any religious order or becoming a sannyasi or relinquishment of all property and worldly affairs performed the requisite ceremonies and formalities by entering into a world of sannyasi by renouncing of the world is a ground of divorce under the fault theory. And the last ground, that is presumption of death, means has not been heard of as being alive for a period of 7 years or more. So that is the other one or the last ground in the fault theory for divorce under section 13.1. And under the Marriage Laws Amendment Act 1976, the very breakdown theory of divorce was inserted under section 13.1a, and these two grounds of breakdown theory under section 13.1a are non-resumption of cohabitation and non-restitution of conjugal rights. So these both are the grounds of judicial separation as under section 10 and restitution of conjugal rights under section 9. So, non-resumption of cohabitation after the decree of judicial separation between the parties for a period of 1 year or upwards after the passing of the decree of judicial separation is one of the grounds for divorce under section 13.1a as one of the ground of the breakdown theory. And the second ground, that is failure to comply the decree of restitution of conjugal rights within 1 year of passing of such decree is also one of the ground under section 13.1a, which is also a part of the breakdown grounds of the theory for divorce. And further, under 1976 amendment, that is Marriage Laws Amendment Act 1976, a new section also was inserted, and that is section 13b, and which otherwise called as consent theory of divorce. So that is divorce by mutual consent, and that divorce by mutual consent under the circumstances, the divorce petition has to be presented by both parties, supported by affidavits to the district court, and the parties should have been living separately for a period of 1 year or more and could not adjust and live together. And finally, there should be mutual request by the parties. They shall have to wait for a period of 6 months and have to move the court once again, and at best before 18 months, otherwise the petition would lapse. So, this is how under Section 13B, which was inserted under the Marriage Laws Amendment Act 1976, provide divorce by mutual consent, which is otherwise called the consent theory of divorce as provided under the Act. And Section 13(2), which provide wife the grounds for divorce, and among those grounds, the first one is husband's bigamy, and the second one are rape, sodomy, or bestiality, which are punishable under Section 375 and 377 of Indian Penal Code. And number 3, non-resumption of cohabitation after the passing of maintenance order under Section 18 of Hindu Adoption and Maintenance Act 1956, or under Section 125 of the Code of Criminal Procedure, which were inserted under the Marriage Laws Amendment Act 1976. And the number 4 is repudiation of marriage. So, repudiation of marriage could be after attaining the age of 15 years or before attaining the age of 18 years, as also it was inserted under the Marriage Laws Amendment Act 1976. So, these are the grounds available to a wife for divorce under Section 13(2). Now, we'll discuss about Section 14, and that is regarding petition for divorce. So, Section 14 provides that no petition for divorce to be presented within 1 year of marriage, but the court can entertain a petition even before expiry of 1 year in cases of exceptional hardship to the petitioner, as it is not explained in the Act. So, it shall have to be presumed that his or her life turned to be a complete hell, or there has been commitment of such a heinous moral and physical offense that it has become completely intolerable to live. The very object of this section is to save their marriage from disaster, as marriage is the foundation of civil society. So, these are the provisions under Section 14 regarding filing a petition for divorce. So, now we'll discuss about Section 15, and that is regarding those conditions of remarriage of divorced persons. So, these conditions are: marriage has been dissolved, the first condition. The second condition, no right of appeal against the decree is available. Number 3, time has expired after filing an appeal. Number 4, the appeal has been dismissed after the 1976 amendment, parties can remarry before expiry of 1 year of dissolution of marriage, and this section shall not available to marriages declared null and void under section 11 and 12. And in our next, we would like to discuss about those grounds in detail with important leading cases of Supreme Court and different high courts which deliver judgments in observing those conditions that we have just discussed, like marriage has been dissolved if any of the spouse want to remarry. So also there should not be any right of appeal against the decree of dissolution of marriage for any one of the spouses. And so also time has expired for filing an appeal. And fourthly, the appeal has been dismissed by the court, and in all such grounds, if it would be fulfilled, a divorced person, either of the spouse, can or could remarry under the Act, and that is also under Section 15 of Hindu Marriage Act 1955. And in our next video, we will discuss those conditions in detail with all leading cases leading to that particular provision.